Welcome to Defensible Sign Regulations. I'm Eric Damian Kelly. I'm a lawyer, city planner, a professor of urban planning at Ball State University. I've spent more than 35 years consulting with local governments on how to implement plans, dealing with the legal side. This is where I blend my legal and planning backgrounds. For about 25 years, I have dealt with the intersection of the First Amendment and land use regulations, which is where we get into issues with signs and billboards, sexually oriented businesses, religious institutions. All of those fall in that intersection, and I'm talking about one of those topics today. Signs can overwhelm an area, of course. Signs can be just plain ugly. Signs can distract and confuse drivers, and we'll come back to that. But signs are useful. The signs I put up may not be the most useful signs you've ever seen, but signs are useful, and we've all been someplace driving across the country with 4 screaming kids in the back of the minivan who will only eat at one particular fast food chain. You really want to see that sign and know where it is. And we all sometimes need directions, need to know where to go. Signs are useful. So why don't we just use zoning to eliminate the ugly and the distracting while preserving the useful? Well, we can do that, but there are some limits on it because signs are protected by the First Amendment, and that limits our regulatory options. The program that you have just started will cover how to create sign regulations that are defensible under the First Amendment, how to address practical issues like temporary signs, electronic signs, real estate signs, political signs, flags, and others, go through some frequently asked questions with answers. And that concludes this chapter. But in the next chapter, we will look at the First Amendment and how it affects sign regulations.